Okay, guys, I'm going to finish up or re-record chapter 4. Some of the slides have been cut down based on kind of like the meat and potatoes that you need to know. The rest of the slides should still be on Aspen though, so if you need to go back and look and kind of fill in some gaps for yourself, that should still be up there. But I'm just going to record these slides for the start of April 20th. Hey guys, so civil rights and civil liberties. Chapter 4 is civil liberties, so we're going to focus on that. Your civil liberties are your basic rights and freedoms that are guaranteed. They are constitutional and legal protections of the individual against government actions. So the ultimate implementer is the legislation, but the ultimate decision maker is the court. So you see that courts and lawmakers are listed here. Your civil liberties and your civil rights are both found in the Bill of Rights. And even though they're both found there, civil liberties are not necessarily clearly defined or understood all the time. There can be conflict, there can be confusion, and there's some gray areas, as you'll see throughout the rest of these slides. But just keep that in mind. Okay, so like I just said, the final interpreter of context and scope is the court. The issues here that you might find is the legislative branch not implementing those rulings. So there can be not only conflict in how they're defined and understood, but also in the court decisions and how those are implemented by the legislative branch. Religion. The First Amendment has two elements. First, the Establishment Clause that says states shall not which states that Congress shall not make no law respecting an establishment of religion. And then you have the Free Exercise Clause, which prohibits the government from interfering with citizens' freedom to worship or not to worship as they so please. Again, like I said in the few slides ago, there's always going to be some level of conflict at times. So sometimes these freedoms with the First Amendment do have some conflict. One would be the government providing chaplains on military bases. My uncle's actually the chaplain for SLED, which is the state law enforcement department in South Carolina. And so that could also be another example of a conflict. So the Establishment Clause, what it actually does is prohibits an established national religion. There are some that argue that the government cannot, and should not favor one religion over another, and others will also argue that the state cannot offer any support for religion at all. A lot of the conflict here arises when religion is mixed with education. So, two court cases. The first one you really need to know for the AP exam is Engel v. Vitale, 1962, and School District of Abington Township, Pennsylvania v. Shemp, 1963. The Supreme Court ruled that requiring students to recite a prayer and laws requiring Bible reading in schools does violate the Establishment Clause. You're later going to see in another case, I believe it's the Santa Fe, and I don't want to mess that up, but I believe it's Santa Fe Independent School District, requires that student-led prayer in front of a crowd with the attention is also violating the Establishment Clause. So school prayer is definitely one of those issues that can be a little bit complicated, but at the end of the day, it's been ruled that requiring students to recite a prayer or laws requiring Bible reading does violate the Establishment Clause. In terms of the Free Exercise Clause, the religions and beliefs that some people hold can actually inhibit actions that society deems necessary. One of these would be the military. Muhammad Ali actually refused military service based on his religious beliefs. You've also got the case Wisconsin v. Yoder, where the Amish were refusing to send their children to public school after a certain age. In this case, the government, or the Supreme Court, excuse me, ruled that they did not have to send their children to public school after a certain age because of their religious beliefs. You've also got blood transfusions and some other medical, procedures that people will refuse to do, even if it could maybe necessarily be the only way to save a life. Those religious beliefs are there and they can decide not to do them. On the other hand, though, the government can deem actions illegal. and they can deem those unacceptable and violating the free exercise clause, or like it not being protected under the free exercise clause. Some of this would be illegal drug use, polygamy. Another one would be, if my religion believes in human sacrifice, if I kill somebody, I can go to jail. Um, so, despite not being able to limit those beliefs under the free exercise clause, they can limit the practicing behaviors. Okay, freedom of expression is next, 4.3. Okay, what is your freedom of expression? Ultimately, to say, it's your right to say or publish what you believe. Two questions that are taken into account is one, can the government censor speech that it thinks will violate the law? And two, what does the First Amendment consider speech deserving of protection? Okay, so you've got prior restraint. What prior restraint is government actions preventing material from being published. So this would be if I write an article and the government says, no, 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 no. Miss Bates's article is not being published, and they stop me, that would be violating my First Amendment rights because of what was ruled in Near v. Minnesota. So in this case, the Supreme Court ruled that the First Amendment protects newspapers from prior restraint. The freedom from prior restraint does depend on context. So the first one is school newspapers are not protected, and the second one, wartime brings widely supported censorship. So again, there are some gray areas, but ultimately, the First Amendment does protect you from prior restraint. Okay, so your freedom of speech and public order in the 1919 case Schenck v. United States, the government decided that it can limit speech that presents a clear and present danger. So the question here is what is dangerous and what is inconvenient? So in Schenck v. United States, you had this guy going around saying, we should avoid the draft for the war, and they said this is a clear and present danger. You've also got the Smith Act of 1940 during McCarthyism. This protects national security and ultimately says that it outweighs your First Amendment rights. However, later they do rule that it is permissible to advocate the violent overthrow of the government in the abstract, but my speech cannot incite imminent lawless action. So once again, and this is going to be the theme on every slide, there's a gray area here. However, for the most part, if your speech is inciting violence, it's most likely not going to be protected. Okay, obscenity. You've got two big cases for this. The first one, 1957 in Roth v. United States. Obscenity is not protected. However, it sets zero standard for what obscenity actually is. About 20 years later, you've got Miller v. California. The decision held that community standards would be used to determine whether material is obscene. And unlike in Roth v. United States, it did start to set some standards. So it said, prurient interest in sex, patently offensive and lacking in serious literary, artistic, political, or scientific value. Still a little unclear, in my opinion, but at least you've got something written out that is attempting to determine whether material is obscene. Your advances in technology, though, really did prove to create some more issues in what was obscene because you can rapidly distribute material. In 1996, you have the Communications Decency Act, which set that age standard of 18. So what's considered for 18 and above is different than what's considered for 18 and below. In 2011, you also had a court that ruled that a California law banning the sale of violent video games to minors was violating the First Amendment because the games communicate ideas. So again, a little bit vague, but ultimately the standard is still that obscenity is not protected. I would say that the definition of obscenity and how you measure that is a little bit difficult, but these two cases, along with further cases, deeming that banning the sale of violent video games does violate the First Amendment, I think shows the change in kind of what's protected. Okay, you've got libel and slander. So libel is the publication, slander is the spoken word of false and malicious statements that may damage someone's reputation. It should be clear too here that a lot of times it can be with the intent to damage someone's reputation. So you've got the 1964 case, New York Times v. Sullivan. Statements about public figures are only libelous if made with malice and reckless disregard for the truth. Public figures are going to have a very high standard of conviction versus private individuals who have a much lower standard of conviction, where they only need to prove that the statements were defamatory falsehoods and were made in negligence. Public figures are going to have a harder time suing for libel because that sets a dangerous precedent of not being criticized. However, if you're a private individual and someone publishes something really bad about you, it's going to be a lot easier to sue in that case. So libel, again, the publication. Slander is the spoken word. Okay, free press and free trials. The conflict with this subject is the right to a free press while maintaining a free trial. So the argument here is that defense attorneys argued that such publicity can inflame the community, including potential jurors, which would compromise the fair trial and your right to a fair trial. The Supreme Court has never upheld restrictions on the press in the interest of fair trials. There have been some exceptions where pretrial hearings can be closed from the press. Also, they've sequestered juries to safeguard them from the influence so that they can't, talk to anybody else, read anything. So this is kind of an interesting conflict to me because you don't think about the kind of merging of two civil liberties into one that would then kind of influence the other in a bad way. You've got the 1978 case Searcher v. Sanford Daily, where it tries to make trials fair by prohibiting journalists from withholding evidence. So this is interesting. You should do some more research on this if you're interested in kind of how the newspapers and the news play a role in how trials end up. But ultimately, this is kind of the conflict and the argument on this situation. Okay, you got commercial speech and the regulation of public airways. Commercial speech is communication in the form of advertising. This is one of the most restricted types of speech, which is regulated by the Federal Trade Commission. Radio and TV is regulated by the Federal Communications Commission. There are required licenses. The content is regulated for cable channels, actually, because it's protected by a paywall. So to be more clear in this, if you plug your TV into like a basic cable, most of that is pretty restricted on and regulated on what the content is. But if you're paying for Hulu, you're paying for HBO, you're paying for one of these streaming services, the content will be more relaxed because you're paying for it. So you kind of like know what you're signing up for in a way. They're not going to stream Game of Thrones on a basic cable channel. That's just an example that came to mind. Okay, campaign spending. You've got three big things that you need to know. The Federal Election Campaign Act of 1971, which limited campaign contributions. The Supreme Court ruled that spending money with the goal of influencing elections, though, is protected speech. 2002, you've got the McCain-Feingold Act. This banned unrestricted soft money donations made directly to political parties, while also restricting some forms of advertising. In 2010, in the Citizens United versus the Federal Election Commission, you see that some parts of the McCain-Feingold Act was struck down, ruling that the First Amendment prohibits government from restricting broadcasts funded by corporations or unions. So campaign spending is a form of free speech because donating money directly to political parties is a way of, protected speech. It's a way of saying what you think and what you believe and who you want to win with your money. Okay, we're going to move on to freedom of assembly. All right, two things. You've got the right to assemble and the right to associate. So the right to assemble is kind of what you think about a march, a protest. The picture I put here is the 2017 Women's March, which is the largest single-day protest in U.S. history. And then right to associate. You have the right to be a part of an organization. You have the right to be a part of an interest group. And it is protected in your right to associate that your group does not have to release the members of that group. So these are two of your rights within the freedom of assembly. We're going to skip ahead to the right to bear arms. So the right to bear arms is your Second Amendment rights. We are out of the First Amendment. We're into the Second Amendment. Guys, it's controversial, if not the most controversial. You've got national, state, and local restrictions, background checks, limited sale of models, maybe even a mental health assessment. Depends on the state, depends on the restriction. You've got a lot of interest groups that fight against gun control efforts. The National Rifle Association is pretty much the biggest one and the earliest one. Advocates of gun control argue that the Second Amendment only applies to the right of a state. It is not the right of an individual to create a militia. So despite being controversial, actually the Supreme Court rarely deals with the issue of gun control. You got two cases. First, really important case, the District of Columbia v. Heller, 2008. The Second Amendment protects an individual right to possess a firearm, and this right is not connected to service in militia. Firearms can be used in lawful purposes, so self-defense within the home, and laws requiring firearm disassembly or trigger locks are unconstitutional. The reason you have McDonald v. Chicago 2 years later is that it restricted the individual's right to bear arms to state and local gun control laws. So this comes off as confusing when you're reading it. What this does is it pretty much takes the District of Columbia v. Heller ruling and applies it to state and local laws. So this is important. This would be through the incorporation doctrine, applying national law, national court decision to the state and local government. Okay, defendant's rights, 4.6. Okay, the first defendant right you've got is searches and seizures. So in order to have a legal search and seizure, you have to have probable cause. This is reasonable grounds of guilt. What does the Fourth Amendment say? It forbids unreasonable searches and seizures. Within this, you have the exclusionary rule, which prevents illegally seized evidence from being used in court. However, you've got some gray area with this. Once again, you have the USA Patriot Act 2001. This was passed only, I believe, I could be wrong, 6 weeks, 8 weeks after 9/11. It gave government powers in wiretapping and surveillance when investigating terrorism. So, your right to searches, your right to seizures, your right to your private information on your cell phone, on your computer, what you say, what you do is sometimes maybe compromised in times of national security. This is the same with maybe freedom of speech. So think about this too. And when you're thinking about your civil liberties, perhaps that your rights can be compromised based on national security. Okay, the Fifth Amendment does forbid self-incrimination and that the burden of proof is on the prosecution. I want to make this clear. You can self-incriminate, but it forbids involuntary self-incrimination. The big case here is Miranda v. Arizona, 1966. This is your Miranda rights, your right to remain silent, your right to know that what you say can and will be used against you, your right to an attorney present during any questioning, and your right to an attorney if you cannot afford one. So this is the Fifth Amendment. This is really getting into what happens for the rights of the accused. Okay, Sixth Amendment is your right to an attorney. The big case that I hope none of you guys have forgotten because we've talked about so many times is Gideon v. Wainwright, 1963. This extended your right to an attorney for anyone accused of a felony at any level of court, and the state must provide attorneys for people who are intellectually not able to represent themselves. The Sixth Amendment and the writ of habeas corpus also guarantees that anyone who is arrested has the right to be brought before a judge. You cannot be held without a charge and a speedy and public trial by impartial juries. Something interesting that I want to add here, I was reading an article a few days ago that the right to a speedy and public trial is actually being kind of violated by the coronavirus. I might add that link in Aspen or on Microsoft Teams if you're interested, but it was a pretty interesting read. However, moving on, an impartial jury is a jury that has been randomly selected. It doesn't include people that would have a clear bias against the person or for the person. Typically, the jury size is 12, but it could be 3, it could be 9. It doesn't have to be 12, but the conviction from whatever the size of the jury is must be unanimous. So moving on to the Eighth Amendment, this forbids but does not define cruel and unusual. So the Eighth Amendment forbids cruel and unusual punishment. However, it does not necessarily define it. In Gregg v. Georgia in 1976, it deemed that the death penalty was not cruel and unusual. About 10 years later, you've got McCleskey v. Kemp, that the death penalty does not violate the Equal Protection Clause of the 14th Amendment, and that no evidence that juries discriminate on basis of race. So this was really interesting because not only did it have to do with the Eighth Amendment, it also had to do with the impartial jury. I remember we talked about this a bit in class, where you had a test that would ultimately, like, say if the jury was impartial or not, or if it was, if the death penalty was granted more to African American men and women. And it's really interesting, this case. So I would recommend looking more into that, reading up on that. So yeah, two big cases that have to deal with the death penalty. Ultimately, what you need to know from this is that the death penalty is not defined as cruel and unusual. Okay, so we're going to move into the right to privacy. The big question here is there a right to privacy? Nowhere in the Bill of Rights is there an explicit right to privacy. However, privacy is implied in the Constitution in a few different ways. You've got the freedom of religion, so your free exercise clause protections, your right to exercise private beliefs. Your Third Amendment forbids quartering soldiers during peacetime, so not coming into your private home and property. You've also got your Fourth Amendment search and seizure, search and seizure, privacy in your own home. A big case here is Griswold v. Connecticut in 1965. This was the right of privacy was made somewhat explicit. It said that this was the issue of birth control and if there was a constitutional right to marital privacy. The most controversial application of privacy rights, however, come in the form of birth control and abortion, specifically abortion. Roe v. Wade happened in 1973, where the right to privacy extends to abortion under the Due Process Clause of the 14th Amendment. Ultimately, what this case says is, one, abortions are protected under the Due Process Clause of the 14th Amendment through the right to privacy. It limits state bans on abortions based on trimesters. So as trimesters, as you are in your first, second, and third, as you go up and are more pregnant, more restrictions and bans can be placed, but it is based on trimesters, and it is also based on state interest. In 1992, you had Planned Parenthood v. Casey, which changed the standard of evaluating those restrictions from strict scrutiny to undue burden. So we're going to finish up with 4.8, Understanding Civil Liberty. Democracy depends on the freedom of expression. In order for people to make intelligent and responsible decisions, information is required. Conflicts between your majority rule and individual rights, 4th, 5th, 6th, 7th, and 8th Amendments, are kind of what make up those individual rights of the accused, defendants' rights, whatever you want to call them. And courts often protect civil liberties from the tyranny of the majority. So pretty much the idea here is democracy depends on these rights that are outlined in your civil liberties. Finally, there is a focus on individualism in civil liberties and conflicts between the individual and group, and the governments and the individual and group typically win. However, you cannot hide from vast government oversight. Technology facilitates government power. The Bill of Rights provides limitation on government power, and it's ironic at the end of the day that in order to expand your freedoms, you may require the expansion of government. So that's all I have for you guys. Again, look at the original Aspen notes if you're confused. Go back to your textbook. If you need me, I am available of access. And so, yeah, let me know. This is chapter 4. Chapter 5 has already been recorded and put on YouTube. So if you want to listen to chapter 5, you can also do that.